Good morning, everyone. Welcome to our webinar on corporate governance for SMEs, staying compliant and managing risk. My name is Michaela O'Connor, and I'm a senior associate in our corporate and commercial team at LegalVision. Now, before we begin the actual webinar, I'll just go through a couple of quick housekeeping items, which you can see on your screen at the moment. So the first is that you will receive the recording and the slides in your email at the end of the webinar. You can submit questions throughout the webinar in the Q&A box in the webinar itself, and we'll answer them at the end. And there will also be a feedback survey after the webinar as well that you can complete. Now, there is a complimentary consultation that you can claim as well. So by viewing the webinar, you will be eligible to claim that complimentary consultation with us and to discuss how we can help your business going forward. So you can either leave your contact details in the survey, which is at the end of the webinar, or you can also contact us via our website as well for that. Now, there will be a poll question that will just pop up on your screen at the moment. So the question is, what area of corporate governance do you find most challenging for your SME? Now, it is multiple choice. So there's understanding directors' duties, making and approving decisions, keeping records and documenting decisions, and keeping up with recent changes in UK company law, or all of the above. Not sure, just here to learn. So if you just want to click which option for yourself now, and then we'll continue on with the webinar. Perfect. So I'll just give you some time to click that. Okay. So next, we'll just go through what we'll be discussing in the webinar today. So the first is, what is corporate governance? Then we'll go through a bit of understanding as to who's responsible for corporate governance, and that will also tie into directors' duties in a company as well. Then we'll go through how to make decisions, hold meetings, and pass decisions. Go through some of the importance of documenting decisions and maintaining up-to-date company records, and then key compliance requirements for SMEs as well. And then at the end, we'll go through a Q&A. So if you submit questions throughout the webinar in the Q&A box, we'll then aim to answer them all at the end for you. Now, the first thing we'll go through is, what is corporate governance? So we'll be discussing, firstly, corporate governance itself, explaining a bit what it entails. We'll particularly be focusing on small and medium enterprises, so SMEs. And for the purpose of this webinar, we'll also focus on private companies limited by shares. So in particular, it's important to note that corporate governance for public companies actually differs quite a lot. There are a lot of stricter requirements for them that need to be complied with. So for today's webinar, we'll just focus on private limited companies limited by shares. Now, in short, what is corporate governance? So it is the systems of rules, practices, and processes by which companies are directed and controlled. Now, for SMEs, the main thing to think about is having proper structures in place in order to run your business effectively, but also to ensure that you're complying with all applicable laws. So for instance, the main one here will be the Companies Act, as that governs all corporate governance requirements. The first step you'll need to think about is having clear corporate documents. Now, they'll outline the decision-making processes, who makes the decisions, as well as the rights and responsibilities of both directors and shareholders in a company. All of those sorts of bits of information will be contained in the Articles of Association, as well as the shareholders agreement. And then obviously if the company has a shareholders agreement, but also in the Companies Act as well. That contains quite a lot of corporate governance requirements. So what's actually involved in corporate governance? Now, the first one, and one of the main ones, is proper record keeping. So we'll go through in a bit what sort of record keeping you need to be adhering to. And then the next is ensuring decisions are made correctly and in compliance with all laws and the company's corporate governance documents. Now, they are what I was referring to before, so the articles of association and the shareholders agreement. Something to keep in mind is the benefits of good corporate governance as well. So the first, which is probably more applicable to companies that are looking for investors or have investors in their company or other stakeholders, other shareholders, good corporate governance will ensure that there is enhanced investor confidence in the company, because it makes sure that investors are secure or feel secure about the investments that they are making. So the investor can be sure that the legal requirements for how decisions are made in the company are going to be adhered to, and everything's going to be above board for how decisions are made. One aspect of corporate governance, which is dealt with by directors in particular, is keeping key stakeholders informed as well. So, for instance, there might be a requirement in the shareholders agreement for the directors to report annually to shareholders and investors on the company's accounts or even the business plan. So that's just an example of a corporate governance requirement. Another benefit of good corporate governance is that it aids in risk management. So it can help to identify and assess and manage risks systematically by having a clear process of how risks need to be decided or dealt with in terms of corporate decisions. And the final one is it can ensure compliance and legal security, and can also prevent legal issues or financial problems arising. So if you're adhering to good corporate standards, companies will usually be complying with all laws. And in turn, by doing that, they can then avoid legal penalties and enhance their reputation by adhering to higher standards. The next thing we'll go through is understanding who is actually responsible for corporate governance. And then I'll also go through a bit around directors' duties as well. So the first thing, I guess, to explain is just around a company structure. So generally, and yeah, you might have just seen that if you do have a question, you can put that in the Q&A box. So in a company, there are usually 3 arms within the company. So you've got directors, shareholders, and then sometimes companies will also have secretaries. Now, directors will be responsible for the day-to-day running of the company, so entering into contracts, making decisions on behalf of the company. Then you've got shareholders who don't necessarily run the company day to day. They may be the same person as a director, but as a shareholder, they have different responsibilities and rights in the company. Generally, shareholders in a private limited company, their liability will be limited to the amount they pay for their shares, and they won't be actively involved in the day-to-day running, but they might be required to make decisions on certain things if set out in the Companies Act or the articles for the company. Some companies might also have what's called a secretary, but not every company has this, and for a private limited company, it's not actually a requirement. Now, a secretary might manage a lot of the actual day-to-day corporate governance requirements. So, for instance, organising board and shareholder meetings, documenting decisions for the directors, or even updating Companies House when a decision is made. Now, whilst a company is a separate legal entity, so a legal person, it does need people to act on its behalf. And as I said before, that is mainly the directors. So normally the directors will be the ones negotiating contracts on the company's behalf, signing agreements, or even enforcing rights against others. And because the board of directors is at the heart of that corporate governance, they're responsible for the company's overall growth, overseeing the management, and also they're also responsible for ensuring accountability to the stakeholders. So that's usually your shareholders. Now, when directors are exercising those powers, they need to be doing that in accordance with the Companies Act, but also in accordance with the company's corporate documents. So the articles of association, which every company will have, but also the shareholders agreement if there is one in the company. So for example, if a company's shareholders agreement has in there that they're is a requirement for shareholders to approve the company entering into a contract. So, for instance, it might be a supplier contract with a value of more than £20,000. The directors, before entering into that contract, would need to seek shareholder approval in order to be able to then enter into the contract. Another example would be under the Companies Act. So before the directors can amend the company's articles of association, it first has to get approval from 75% of shareholders to adopt the new articles. And that's a requirement in the Companies Act. The next thing is that directors are responsible for managing the company, as I said, but they also need to make sure they're adhering to other standards. So one of those is making sure company accounts are up to date and also reports are properly prepared, as well as dealing with all of the other day-to-day decisions of the company. Some directors will actually be working in the business. They're usually what we call executive directors, and they could also be employed or contracted by the company or have a director's services agreement with the company as well. But other directors are usually called non-executive directors. Now, non-executive directors might attend directors' meetings and contribute to decision making, but they're not typically there day-to-day running the company. So some of the decisions, which I've already touched on a lot of these that you'll see on your screen, but a lot of the decisions that directors make, so the day-to-day operations, hiring people, leasing premises, entering into contracts, they'll also be involved in issuing shares in the company, although that in particular would be subject possibly to shareholder approval before the directors can then issue shares in the company. Other decisions they might make are declaring and paying dividends to shareholders or authorizing the company to take out a loan, for instance. So then moving on to directors' duties, which are very important in corporate governance. So the first arm, and you'll see there's 3 arms really that apply to directors' duties. I won't go into a lot of detail about these. We have done another webinar on directors' duties, which you can find on YouTube, I think. And that goes into more detail around directors' duties. We also have a directors' duties guide, which you can reach out to us for if you want a copy of that as well. But the first are the duties that are set out in the Companies Act. So there are 7 main duties, which you'll see on the screen. These are what we call general duties. So the first one, for instance, to act within your powers. An example there would be you cannot exceed the authority as a director granted by the Companies Act or the shareholders. So, for instance, as I was saying before, if there is a decision that is reserved for shareholders in the articles or the shareholders agreement or the Companies Act, for instance, then the shareholders' approval is required in order for then the directors to then pass that decision. Other decisions: duty to promote success of the company, duty to exercise independent judgment. So I guess they're practically, that's often an issue where, for instance, a director would rely on the advice of a third party. So for instance, an accountant or a consultant. So as long as the director is exercising their own independent judgment when evaluating that advice that they've got elsewhere, they wouldn't be in breach of that duty. Then the others are duty to exercise reasonable care, skill and diligence, avoid conflicts of interest, not accept benefits from third parties. And then the last one is declare an interest in transactions with the company. That one in particular actually is quite similar to the duty to avoid conflicts of interest. So if you have an interest in any transaction that the company is entering into, and you then need to declare it to the other directors, if you don't declare it, you would then be in breach of this duty, as well as possibly a breach of the conflicts duty as well, because you have failed to prevent a conflict of interest. Then the second arm is what we call common law duties. So these are law that's developed over time through court cases, and they're also known as what fiduciary duties. So an example here would be the duty to disclose wrongdoing or conflicts of interest, which, as you can see, sort of ties into the general duties under the Companies Act as well. Then there's also other duties under other laws or statutes. So, For instance, insolvency laws or even environmental and health and safety legislation. An example there, which you can see on your screen, is that directors can actually be held personally liable for breaches under work health safety laws. Normally, those work health safety laws will require companies and also directors personally to ensure that the company's operating, say, safe working practices, environmental stewardship and chemical regimes, for instance, if applicable. And a breach of that, a director could possibly be held personally liable for that as well. One thing I did want to touch on here as well is also the concept of a shadow director. So this is usually someone who is performing the role of a director without actually being named or appointed as a statutory director under the Companies Act, or even noted on Companies House as a director. Now, shadow directors could also be held personally liable for these directors' duties as well, if they're acting in that role of a director and should technically legally be appointed as a director. So even if you aren't a named director, you need to keep that in mind, whether you should actually be legally appointed as a director in order to comply with corporate governance requirements. The next thing is that there could also be consequences for breaching the duties. So firstly, there could be civil penalties imposed if there is a breach of directors' duties. An example there would be personal liability for losses caused, disqualification as a director. And in some serious circumstances, so more serious cases, there could also be criminal penalties imposed for breaching directors' duties, so fines or imprisonment. It could also lead to the removal of a director from office by way of a requirement under the Articles of Association or the shareholders' agreement of the company as well. Then for more serious breaches, depending on which duty you've actually breached and the fallout of the breach and the impact on the company or the shareholders as a result of that breach, a court could also impose other restrictions and requirements. So, for example, if you've made a personal profit in breaching the duty, the court could actually order you to repay the amount of the profit that you've made to the company that you're a director of. If you cause the company a loss in the course of breaching the duty, a court could then order you to compensate the company for that loss. If you took company property, you could be ordered to return it. And then the last one is that if you plan to breach your duty, so for instance, if you try to enter into a contract which is in competition against the company you're a director of, the court could actually issue an injunction being an order not to do something. So they're all things to keep in mind in terms of duties and complying with them. Now we'll go on to how to make decisions, hold meetings, and pass decisions, and that all ties into ensuring good corporate governance. So the first thing to keep in mind is that decision-making needs to adhere to the company's Articles of Association, Companies Act, and Shareholders Agreement, if there is a Shareholders Agreement. There are different thresholds for different types of decisions and the manner in which they need to be approved. So the main ones that you see, that there are others as well, but the main ones that you see are ordinary resolutions, which is usually a threshold of 50% or more, special resolutions, which is 75% or more, and then unanimous resolutions, which requires 100% approval for that type of decision. There is also differences between board and shareholder decisions or meetings. So, for instance, if the company wanted to approve the issue of new shares, it might require an ordinary resolution of the directors, but also a special resolution or even a unanimous resolution of the shareholders. So it's important to be reviewing the articles, the Shareholders Agreement, and the Companies Act when a company wants to make a decision, particularly where it impacts the shareholders and the share capital, to review those requirements, work out what threshold for the decision needs to be met, and then that threshold needs to be met in order for that decision to be passed. Now, most day-to-day decisions will be made by the board by way of ordinary resolution, so more than 50% of the board approving that. So for instance, if you have 3 directors, if 2 of 3 agree, usually that decision will then pass. Obviously, this might differ in your articles and your shareholders agreement, but that's usually the threshold. And then shareholders might also have to vote on something. So as I said before, a main example there would be if the company looks to amend the articles of association, it then needs to get 75% of shareholder approval under the Companies Act. Something else to keep in mind here is that a shareholders agreement could also set out other restrictions for decision making. Now, we usually refer to these as business critical matters, and they're usually certain matters which have a higher threshold for decisions to be made as opposed to the ordinary resolution of directors. So an example here would be if a shareholders agreement said that you needed an ordinary resolution of directors with a founder consent, that would then require 50% of directors to approve, but also a founder, and which is usually named in the articles or the shareholders agreement as a certain individual, but also the founder to consent to that decision being passed as well. Or some decisions might require a special resolution or even a unanimous resolution of shareholders, and usually they're for more serious decisions. So it might be where the company wants to change the share capital, or if the company wants to enter into a loan over a certain value, which is high risk, the shareholders might want to be involved in those decisions. So that's where your shareholders agreement might also put in place further requirements for decision making. Now, the next thing is meeting requirements. So this is both board and shareholder meeting requirements. So when there is a board meeting, you'll need to make sure that proper notice is given. That is usually referred to as reasonable notice, unless the company's articles state otherwise. There'll also be a quorum that needs to be met for a board meeting to proceed. Now, when I say quorum, I mean who has to be present in order for that meeting to actually proceed. And usually that's set out in the articles as well. And an example here would be that the quorum says you need 2 directors present, or even 2 directors with a founder present, so that a founder also has to be present for a meeting to proceed. There'll also be voting procedures set out in the articles. So for instance, for directors, it's usually 1 vote per director. So for example, if you have 3 directors, 2 of 3 would then pass that decision. And one thing with board meetings to consider is conflict of interest management. So normally in the company's articles, you will see a clause around conflict of interest for directors, and it's building on that duty to avoid conflicts of interest under the director's duties under the Companies Act. So for example, if a director has a conflict, they need to then notify the directors and abstain from voting on the matter which they have a conflict on, unless approved by the directors or in accordance with the articles. So that's something you'd have to review your articles and keep in mind as well. Then the flip of that is shareholder meetings. So a shareholder meeting might be required for specific decisions. It also, in your shareholders agreement, it might also require an annual general meeting of the shareholders per year, or even say quarterly, just depending on what the shareholders agreement says. And these might be required for decisions like amending the articles, amending a share class right, or even under the Companies Act, there is the ability for shareholders to remove a director in certain situations, and they would then need to comply with those requirements under the Companies Act if that was looking to be done. And there, in that specific instance, there's actually quite strict requirements for shareholder removal. So there's a lot of different notice requirements to directors and other shareholders if that's looking to be done. So as with board meetings, with shareholder meetings, you also need to make sure there is proper notice. So for a general meeting, this is what we refer to as a shareholders meeting. Usually there is a 14-day notice period for that, unless the Companies Act or the articles specify a different notice period. So as I said before, if the shareholders are looking to remove a director, that notice period is actually longer than 14 days, and there's special notice requirements for that as well. Then there is still a quorum requirement, so a quorum being who has to be present for the meeting to proceed. That is also usually set out in the articles. So an example would be 2 shareholders with more than 50% of the shares have to be present for the shareholder meeting to proceed. And then voting procedures as well. usually set out in the articles. With shareholders, it's usually set out by way of show of hands or a poll. And the poll usually then relates to your percentage of shares that you hold in the company, which differs to how directors pass decisions, which is one vote per director for a decision to pass. Then with both special and ordinary resolutions or unanimous, you can replace board meetings or shareholder meetings with written resolutions. So they can be used as an alternative to actually having a physical or an electronic meeting. But that also needs to be set out in the articles that a written resolution can also be used. And in the example of a director's written resolution, usually it will require a unanimous resolution. So all directors have to sign that written resolution in order for it to pass. Something else to keep in mind here is delegation of authority framework. So obviously there's quite a lot of decisions directors need to make day to day. They can delegate their decisions if the articles of association for the company allow them to. And generally, if directors delegate their decision-making powers, they would then have a delegations of authority policy in the company that would then document what decisions could be made by who. And usually what you see is it also can be tied back to monetary thresholds. So an example would be if the company wants to sign a supplier contract, it's delegated to a senior manager in X department, but the contract needs to be less than, say, £5,000. So that is when that person could then sign the contract on behalf of the company and bind it. One thing to note here, though, is that directors cannot delegate the signing of deeds on behalf of a company from the directors. So if a deed, so in contracts you have agreements or deed, if a deed has to be signed by the company or on behalf of the company, directors have to be the ones to sign that. They can't delegate that power. The next one is importance of documenting decisions and maintaining up-to-date company records. Now, first thing to touch on here is it actually is a legal requirement in particular to maintain statutory books and records. So I'll touch on some of them now, but I can't go through every single thing in the Companies Act. But some of the main ones I'll touch on are that the company needs to maintain a share register. So that's also referred to as a members register, as well as a register of directors, secretaries, director addresses, home addresses, persons with significant control, which are called PSCs. They all need to be maintained in accordance with the Companies Act. So if you don't have one of those in place, you really should be getting that in place because it is a requirement under the Companies Act to have those documents in place from the date of incorporation. Then the other thing to keep in mind is board meeting minutes or general meeting minutes, so shareholder meetings, or even written resolutions if you're not holding an actual meeting. They need to be kept for at least 10 years under the Companies Act. So Section 248 and 355 if anyone was interested, but you need to be keeping those records for at least 10 years, and that is a requirement under the Companies Act as well. So that's why it is important to keep a record of all board and shareholder meetings, even if it is in the form of a written resolution, because it is legally required. In certain situations as well, the reason that you actually have those written records of the minutes or the resolutions, you might need to actually be required to upload those to Companies House as well in order to approve a decision. Now, it is also important to keep in mind that if you were looking for investors to come on board, they might also want to review your corporate governance documents and check that everything has been adhered to as well. And then other thing here to keep in mind is electronic decision making. So you can actually sign decisions and minutes electronically now. We usually recommend a signing platform like DocuSign. And you can also hold meetings via electronic platforms, so like Google Meets or Teams, if the notice of the meeting allows for that to happen. Then there are, the next thing is, importance of good documentation. I'm just mindful of timing because we will have to allow for some questions in a minute, but there's not too much left on the main slides. So in terms of good documentation and keeping your documentation. The other reasons are it is also a way to ensure legal protection for directors. So, for instance, if shareholder approval was required for a certain decision, for directors to then allow for that decision, by having a document showing that shareholder approval, the directors can then show that they had the requisite approval at that time, which again is then legal protection for the directors that they acted in accordance with their duties and the requirements under the documents. So it's just evidence basically of corporate of governance being complied with. Then the last thing is key compliance requirements for SMEs. So as I said before, it is important to keep accurate records. If a decision isn't approved in accordance with the requirements under the Articles of Shareholders Agreement or the Companies Act, then it could be considered invalid and actually unwound in more serious cases. So if directors acted outside of their authority, then they could be held personally liable for directors' duties in those circumstances. There are Companies House filing obligations as well. So a company needs to file an annual confirmation statement. Then you also need to be filing annual accounts as a company as well. If the annual confirmation statement isn't filed annually, the company could be risk being struck off the register as well. So that one is very important. Same with annual accounts. Then if the company has any change in notification, changes in it, so for instance, it issued further shares, it needs to notify Companies House of that within a certain time frame. So in the example of issuing further shares, it has to notify Companies House within 1 month of that occurring in order to ensure it doesn't get a late filing fee or monetary penalty from Companies House. And the last thing is tax and accounting compliance. So corporation tax is payable by a company each year. It is, well, the company is required to register within 3 months of starting to do business. So not from the date of incorporation, but within 3 months of starting to do business. So that could include buying, selling, advertising, renting a property. So usually it coincides within 3 months of incorporation. Company will also need to register for VAT if it hits the threshold, which is £90,000. At the moment, it's £90,000 for the last 12 months. Or if the directors expect the turnover to go over that amount in the next 30 days, they also have to register for VAT as well. And then there's also PAYE obligations. So there is a requirement for a company or a business, any business, to register for PAYE if it does employ employees. So that actually does bring us to the end of the main part of the webinar. Now, you might find this publication useful. It does go into some of the areas I went on today, but also provides a bit more information around meetings and how to actually structure a board or a shareholder meeting. So I'd recommend downloading that. The QR code will also be available towards the end of the webinar as well. We do have another webinar coming up, which is Legal Essentials for Online and E-commerce Businesses. So that is on Tuesday, the 5th of August at 11 a.m. And you can register on our website. The link is also there, legalvision.co.uk/events. Now, I'll ask if anyone has questions that they want to submit, because I'll go through them in a minute. While you do submit them, I'll just run through LegalVision's membership. So we do offer a membership which is a little bit different to other law firms. It essentially gives your business unlimited access to a full team of specialist lawyers across different business areas. It will give you access to all business as usual legal needs. So it's kind of like having your own in-house legal counsel, but for a fraction of the cost. So you'll see some of the things on your screen that we can assist with. So for instance, unlimited document drafting and reviewing of business contracts, legal advice consultations, or even domestic trademark registration. So if you're interested in the membership and how we could help you with that membership, you can request that free consultation, as I said, when the survey appears at the end of the webinar. So now we do have around 10 minutes for some Q&A as well. So I'll just check if the questions that have been submitted. I'll just put them up, and you can keep submitting them as well. I'll just try and answer them as they come through. Okay, so in terms of the first one, okay. Oh, I think this one might have maybe been added before we went through this, but it was, can a director delegate their duties? So as I said before, yes, you can delegate your duties if it is set out in the company's articles that you're allowed to do so. Generally, under common law, directors are able to or entitled to delegate their duties as well, but it doesn't actually absolve the director from their duties, their director's duties. So even if you delegate, say, for instance, the signing of a contract, and it's later found that that contract was then by way of breach of the director's duties somehow, the director could still be held personally liable for breaching their director's duties. So even if you're delegating your duties, you need to make sure that you're still across everything that's happening in the company. Another one is, are there defenses if you breach a director's duty? So I guess we did do a whole webinar on director's duty, so you could just refer back to that as well. But in terms of defenses for breaching a director's duty, usually what will happen is if a company has worked out that they didn't get the required approval. So for instance, if it issued shares to someone a year ago and the shareholders didn't actually approve the issue of those shares at the time and they were required to, they will then do what's called a ratification now, if provided the shareholders are all on board with that decision that was made. That ratification is where the shareholders of the company then ratify the director's breach of their fiduciary duty at that time, which will effectively then affirm the transaction from then. And then that will then release the director from any personal liability by ratifying that decision. Now, that ratification would need to occur without the votes from the director or the person connected with the director. Like, say, if the shares were issued to a family member, those individuals couldn't vote on that decision. So the ratification needs to be done in compliance with laws and to be done above board to make sure that it actually is also legally enforceable as well. Then you could also, I guess, defenses to breach of duties, you could also get relief from the court. So if proceedings are brought against a director for breach of their duty, the court might actually relieve them from their duty if they consider that they've acted honestly, reasonably, and that they'll consider all of the circumstances of the case to see whether their director's duties have been complied with as well. And the last one, I think this was about, so when might a person be considered a shadow director, and what problems might this raise when a company is in financial difficulties? So I guess the first time of this is, it kind of ties into what I mentioned before around if someone is acting day to day as a director in the company, they are making decisions as if they were a director, entering into contracts, making all the decisions of the company. That's when they could be considered a shadow director. But that is difficult because it is such a case-by-case basis. So a court would need to consider all of the circumstances of the case to then determine if you would be considered a shadow director. And if you're acting in the role as a director, that they would consider everything for those circumstances. So it doesn't necessarily mean that if you're acting as a named CEO, but you're not a director at law, that you wouldn't be considered a director, but it just would depend on the circumstances of the company in question. And I think the second arm of that question was, what problems might this raise when a company is in financial difficulties? Well, I guess the main one there is one of the director's duties is to make sure that the company isn't trading insolvent. If it is trading insolvent, the directors have they could be held personally liable for that. There are certain circumstances where companies will put in place directors and officers liability insurance, which is a way to then protect directors when they're performing their duties. But there are limitations to that. So if a director has breached their director's duties or acted fraudulently, usually that insurance then cannot be relied upon. And I guess what problems might arise when a company is in financial difficulties. Yeah, I think that pretty much covers that question. Now, just see if any other questions have come in. Okay. So I think that's all of the questions that we've had that have come in. If there's no others, I don't think there are. Okay, well, I guess that is all the time that we have for today. So if you do have any other questions that you think of after the webinar is finished, you can submit them via the survey at the end. You can also ask for that free consultation or complimentary consultation that I did refer to, and to also learn a bit more about how our membership could help you. Now, while this was a free webinar, we do also value your feedback. So in that survey, even if you don't want to request that complimentary consultation, if you could complete that, that would be great. So thank you for joining us. And yeah, we'll now finish up the webinar.